Welcome to everyone. Thank you for joining us on this extremely snowy Tuesday afternoon in central New York. For those of you who thought winter was over like me, you are very disappointed today, but it's all part of living in central New York, so welcome. All right, we're going to start off with our weekly COVID update. As you can see from the table on the screen, the numbers are actually looking quite good. We've seen a significant decrease in cases reported, daily cases reported over the past 90 days. Cases are down to about 1,200 a day, which was the daily average as of yesterday. That's a 45% change over the past 14 days. So that's significant that these numbers are all looking great. Next slide. As you can imagine, with the numbers looking the way they are, the colors on our state of New York chart are also good. A lot of yellow, a lot of light orange. No more of that dark orange red that we were seeing last year around this time. Case numbers significantly decreasing in most every county. There are those anomalies where you see, for example, in Franklin County, 38% change over the past 14 days, but that's only 9 new cases. So it's all relative based upon the size and sample size and number of new cases within the county. Okay, next slide, please. All right, as a continuation to a series that I started a little while ago on employment litigation, I'm going to talk a little bit today about preparing responses to administrative charges. Next slide, please, Kathy. By way of quick review, there are a number of employment discrimination and retaliation statutes, both on the federal, state, and local levels. For example, Title VII of the Civil Rights Act of 1964 is a federal law that prohibits discrimination and or retaliation on the basis of race, color, religion, gender, pregnancy, sexual orientation, and national orientation. We also have on the federal level, the Americans with Disabilities Act, the Age Discrimination in Employment Act, which are pretty self-explanatory there. And then we also have the New York State Human Rights Law on the state side, which prohibits discrimination on all of the categories that are listed there on the screen. Next slide, please. And we also have the New York City Human Rights Law, which has its own protections against discrimination on the identified bases there. Next slide. So when an employee believes that they have been discriminated on one or more of the bases identified in those statutes that we talked about, there are a couple of different avenues that they can pursue a claim. First, they can pursue a claim through the administrative process. So for example, in New York, we have the New York State Division of Human Rights, which is the state agency tasked with enforcing the New York State Human Rights Law. So if an employee believes, for example, that they've been discriminated against on the basis of their race, they could file a complaint with the New York State Division of Human Rights, and their claim would proceed through the division process that we're going to talk about in a minute. Similarly, if someone in New York City believed that their employer had discriminated against them on the basis of their gender, they could file a claim with the New York City Commission on Human Rights. On the federal side, the administrative process is fairly similar. If an employee believes that they've been discriminated against in violation of one of the federal statutes that I identified, they could file a claim with the Equal Employment Opportunity Commission. Now, employees, in addition to the administrative process, also have the opportunity to go to courts, both federal and state courts, to prosecute their claims. Their ability to do so is limited by the administrative process and what avenues they pursue in the administrative realm, and we can talk about that in just a minute. Next slide, please. So here's the process, the general process. Look at the process from 50,000 feet in the state realm. So the Division of Human Rights typically processes a claim once it's filed by an employee or their attorney. The division will then provide the claim to the employer, which is you in this case, and give you an opportunity to prepare a response. And then the claimant will have the opportunity to submit a rebuttal after the employer responds. The division will then conduct a factual investigation, which may include requests for specific documents and or interviews of the parties involved. After the initial investigation is completed, the division will provide its initial determination. For those of you who've been through this process, this can either come in the form of a probable cause finding or a no probable cause finding. Please note that at the division stage or in the division process, a no probable cause finding is equivalent to a dismissal. If there is a probable cause finding, then you proceed to a mandatory pre-hearing settlement conference and a public hearing, which is essentially a trial, and then a final order by the commissioner. At the New York State Division of Human Rights, the employer could be ordered to reinstate the employee, provide training of staff and other equitable remedies, but the division can also issue monetary fines for back pay, compensatory damages for mental anguish, attorney's fees, civil fines, and penalties. So that's a very high level look at the division process. Next slide, please. The EEOC process on the federal side is very similar. There's a charge of discrimination, there's a response by the employer, there's a rebuttal by the complainant. There's a factual investigation, which can include requests for documents and witness interviews as well. The possible outcomes on the EEOC side are a little different though. The Division of Human Rights has the ability to issue penalties, fines, reinstatement. The EEOC does not. What the EEOC can do is they can either dismiss a claim or find that there's probable cause, but in either event, they will issue what's called, or they can issue what's called a right to sue notice to the employee that notifies the employee that within 90 days, they have to file a complaint in federal court. If there's a probable cause finding, there can be an invitation to conciliation from the EEOC. This is an invitation to try to settle the case. If conciliation is not successful, the EEOC has a right to file a lawsuit in federal court. This very often does not happen. And if the EEOC decides not to sue, the complainant will receive a 90-day right to sue notice. And then ultimately will end up in court as well. So the resolution of a division administrative claim is a little different than an EEOC claim. Next slide, please. So what I want to talk a little bit about here is how you respond or prepare a response to an administrative charge. So there are some very basic things on here, but I like to be basic because I like to be thorough. The first thing is you're going to want to identify when the response is due. The Division of Human Rights will always give you a very short period of time. My experience with the Albany and Rochester regions is that they'll give you an extra 14 days, but they're not going to give you any more than that to respond to an administrative charge. So you really want to focus on when is your response going to be due? Are you going to be requesting an adjournment of that? If so, make sure you do it in a timely manner. Determine whether insurance is available. Not everyone has employment practices liability insurance, but some employers do. If you do have that EPLI coverage, make sure you're tendering the claim to the carrier so that the carrier can work with you to cover the claim. You also want to determine who's going to be preparing the response. Now, I will tell you that as an attorney who handles these claims on a regular basis, it's always best for an attorney to handle your response to an administrative charge. Attorneys can evaluate the issues, in terms of the law, and they can present the case in a way that's understandable to the investigator in the division. You're also going to want to identify relevant documents. So typically we always start off with what are your EEO policies? What are your anti-discrimination or harassment policies? Make sure you have those and make sure they've been communicated to the affected employees. You're also going to want to gather the employment file for the individual who's bringing the claim, any letters, emails, texts, or other correspondence that would be relevant to whatever's being claimed in the complaint. Relevant disciplinary records. So for example, if you have an employee who has a history of disciplinary issues, you ultimately terminate that individual. The individual then files a complaint with the division. And as part of your response, you're going to want to say, no. This individual wasn't terminated because of his or her race or gender. They were terminated for legitimate reasons. Look, here is the history of their discipline. Here's the history of the actions that led to their termination. You're also going to want to gather up comparator information. So you want to be able to say to the administrative agency, look, we didn't treat this individual any differently than we treated everybody else. Here's a similar situation, and here's a similar outcome. That's all very helpful in responding to a discrimination charge or complaint. Next slide, please. You're also going to want to conduct an investigation to the extent you can. If there are witnesses who are available who would have relevant information, you or your counsel are going to want to talk to them, understand what happened. If it's an HR manager, understand why the particular adverse employment action was taken, understand the basis for whatever determination was made. So you're going to want to talk to witnesses. Then you're going to identify whatever defenses are potentially available. So what I just talked about just a moment ago was we had a legitimate, non-discriminatory or non-retaliatory reason for taking the action that we did. So then you're going to take all the information that you gathered and you're going to prepare a written response. The written response is typically in a letter format. I say here, determine how much detail to provide because there is some strategy involved in that. There may be circumstances where you don't want to provide the administrative agency with a ton of information. There may be circumstances where you know a lawyer has ghost written a complaint on behalf of a complainant. And all the lawyer is trying to do is get some free discovery, some free information before it goes to court. So there's some significant strategy involved in that decision. You're going to want to identify relevant exhibits. Are there exhibits that you want to provide to the administrative agency, knowing that your response is going to go to the complainant or his or her attorney? You're going to want to provide a very clear explanation of the facts. Think of it as what you are trying to persuade the investigator that what you did was not discriminatory or retaliatory. And then after you prepare and submit your written response, you're going to wait for the agency to respond with either a request for additional information or a request for interviews. And then you prepare for those as they come up. So next, I think that's the last slide, right, Kathy? Yes, thank you. All right, so that is a general overview of the process. We prepare responses to administrative complaints all the time. Every bond attorney in the Labor Department works on these things, myself included. So if you have any questions, please don't hesitate to reach out to me or to anyone in our Labor Department for help with your response to an administrative complaint. All right, next up, we have Travis Tallarico. Travis has been on the webinar many times before. Travis is here to talk to us about mandatory arbitration clauses and some recent case law that impacts the statute that prohibited specific types of mandatory arbitration clauses. Travis, welcome.
Thank you very much, Adam. Hello, everyone. Good to be back. So as Adam laid out, we're going to be talking today about a recent court decision out of the Southern District of New York, which, in our opinion, significantly broadened the scope of a bill that was signed into law by President Biden around this time last year, which effectively prohibited the mandatory arbitration of workplace sexual harassment and sexual assault charges. So if we hop to our next slide here, we can dive in. So as a bit of background as to the law that was signed that's relevant to this topic today, the EFAA, or the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, also known as the #MeToo bill, was signed into law by President Biden on March 3rd, 2022. So what did the EFAA do? So it amended the Federal Arbitration Act to invalidate mandatory arbitration agreements that otherwise would preclude an employee from filing a lawsuit in court arising from workplace sexual assault or sexual harassment. Historically, these provisions are very common in employment contracts. A lot of times it's boilerplate language that's just kind of inserted into these agreements that oftentimes employees may sign without understanding the full implications of them. And I guess before we go any farther, just a brief background on the difference between arbitration and actual litigation. Arbitration is a more informal legal process, which still allows for a legally binding result. But there's several key differences between that and an actual court filing. The first is that generally the process is meant to be more informal. It's usually cheaper for both parties to navigate. But also, and a reason why a lot of times employers like to have these clauses in employment contracts is there's generally a significant more amount of confidentiality in arbitration proceedings than in actual court proceedings. Arbitrations are usually meant to be kept confidential, and all the information that is disclosed usually remains between the parties. Next slide, please. So the specific case that we are going to be talking about, which, as I mentioned earlier, broadened the scope of the EFAA, is a case called Johnson versus Every Realm Incorporated. So to start from a high level of what the actual holding of this case was before getting into a bit more of the nuances here, effectively, Judge Engelmeyer out of the Southern District of New York held that the EFAA prohibits not only the mandatory arbitration of workplace sexual harassment or sexual assault claims, but also prohibits mandatory arbitration of other related claims brought in the same case. Now, an important thing to note here is that in a companion case that was decided simultaneously with Johnson, in the case referenced here, Yost, Judge Engelmeyer also held that for the holding in Johnson to apply, so for the EFAA to prohibit other claims that were brought from being subject to mandatory arbitration, the sexual harassment claims must be plausibly pled. So effectively, the sexual harassment or assault claims do tie the rest of the related claims to the case and will determine whether or not they are subject to the prohibition from mandatory arbitration. Next slide, please. So diving in a bit to kind of the meat of this case. So the language of the employment agreement at issue here was an agreement that any dispute or controversy arising out of or relating to any interpretation, construction, performance, or breach of the agreement shall be settled by arbitration to be held in the state of New York in accordance with the rules then in effect of the American Arbitration Association. Subsequently, the plaintiff in this matter brought a lawsuit against Evergreen, his employer, for not only sexual harassment, but racial bias, retaliation, and pay discrimination. And then Evergreen moved to compel arbitration of such claims pursuant to the employment agreement. Next slide. Now, focusing on the actual language of the EFAA, that provides that notwithstanding any other provision of this title at the election of the person alleging conduct constituting a sexual harassment dispute or sexual assault dispute, moving on without belaboring reading of this entire paragraph, with respect to a case which is filed under federal, tribal, or state law and relates to the sexual assault dispute or the sexual harassment dispute. So there's a couple things that are important to focus on here. The first is at the election of the person alleging conduct. So it's important to note that the EFAA does not entirely prohibit arbitration of these types of claims. If the person who is bringing the claim elects to go to arbitration, that is entirely within their right. The distinction here is it prohibits mandatory arbitration. But more importantly, related to the holding of this case is you'll see that we have case italicized here. And as we move into the next slide, this is what the judge kind of focused on in terms of coming up with this holding here. So this is some quoted language from the decision referencing the ordinary meaning and definition of the word case. The text of 402, which is the EFAA, makes it clear that the invalidation of an arbitration agreement extends to the entirety of the case relating to the sexual harassment dispute, not only the discrete claims, so not exclusively the claims of sexual assault or sexual harassment. And so the actual holding from the court was that where there is alleged conduct constituting a sexual harassment dispute, the EFAA makes pre-dispute arbitration agreements unenforceable with respect to the entire case, relating to that dispute. So a couple key takeaways here, and I guess just going back to what actually happened and is continuing to happen in the case referenced, is effectively the language of the agreement that was cited earlier in this slide would have prohibited arbitration of not only the plaintiff's sexual harassment claims, but any other claims that he would have brought arising out of his employment with his employer. So this holding is significant because it finds that not only does the EFAA prohibit mandatory arbitration of specifically just sexual harassment and or sexual assault claims that occur in the workplace, it also extends to prohibiting mandatory arbitration of any other related claims that are brought along with the sexual harassment claims. This holding is to date seemingly the most substantial application of the EFAA. The majority of the other cases that have been decided to date are focusing on whether the EFAA is to be applied retroactively, and also clarifying that claims must have accrued after the effective date of the EFAA to receive its protections. With all this being said, I would be surprised if this decision does not get appealed, if nothing else, because it is posed to set potentially some binding precedent, which will become even stronger precedent if it does get appealed to the Second Circuit, which is the appellate court for the district courts of New York.
Okay. Thanks, Travis. We appreciate the information you shared. Good afternoon, everyone. Adam had to step away, and so I have big shoes to fill, but I'll do the best I can. Next up, Michaela Mancini, a litigator here in Syracuse, is going to address some of the recent developments with the Child Victims Act. So I'll turn it over to you, Michaela.
Thank you, Tom. So yeah, as we all know, we've been dealing with the Child Victims Act and the cases that have come from it since around 2019. So I'm here today to just give a little bit of background information on it and some developments that we've seen. So in 2019, former Governor Andrew Cuomo signed the Child Victims Act law. This law had two major parts. First, it changed the statute of limitations for victims of childhood sexual offenses to bring civil claims until the age of 55. And second, it created a 1-year look-back window in which any person who was a victim of a childhood sexual offense to bring a civil claim against any party whose negligent or intentional act was the cause of this abuse. Most importantly, this window allowed claims regardless of when they occurred. The look-back window was originally set to close in 2020, but was extended until August 2021 due to the COVID-19 pandemic. By the time the window closed, New York saw an influx of around 10,000 CVA cases. Because many of these claims are decades old and many of the alleged abusers deceased, entities like schools, churches, and other organizations are being named as defendants in these cases. The basis of liability for these entities, in a nutshell, is that they knew or should have known that their employee had a propensity to abuse a minor and that they negligently supervised and or retained these individuals. So now that we're a 1.5 years out from the close of the look-back window, we're starting to see some movement in the litigation of these cases and some developments in this corner of the law. Notably, when the CVA was first passed, initial questions arose about whether the look-back window was a violation of the Due Process Clause of the New York Constitution. This was an extension in part of defendants' inability to defend these cases based on the passage of time and the loss of important evidence and important witnesses. But recently, the New York Appellate Division for the Fourth Department answered this question and affirmed that the look-back window of the CVA was permissible under the Due Process Clause from the New York Constitution. The court found that the look-back window first was a reasonable response and second to remedy an injustice. In making this decision, the court noted that due to the trauma associated with childhood abuse, many survivors are unable to come forward with their claims until well into adulthood. Based on this, the court found that the CVA does not violate the Due Process Clause and denied the defendant's motion to dismiss in that case. So another issue we are starting to see come forward in these cases is whether or not they can be dismissed at the summary judgment stage. Summary judgment is a motion practice that allows for a case to be dismissed before proceeding to trial. As some of you may or may not know, a motion for summary judgment requires a showing that there are no issues of material fact, and that therefore the judge can make a decision about the case based on the law alone. A recent decision that we saw in Delaware County has highlighted an issue that entities may face in making a motion for summary judgment in these CVA cases. I'm not going to get into the details of the case, but the judge found that there was an issue of fact because the defendant could not produce testimony from any witnesses that had firsthand knowledge of the events due to the passage of time since the abuse. Based on this, the judge found that the decision regarding whether the school had notice of the abuse was dependent on an evaluation of the plaintiff's firsthand testimony, which required a question to be left for the jury. And therefore, the court denied the motion for summary judgment and the case moved forward. This is something that we anticipate seeing as we begin to make motions for summary judgments in these CVA cases. In that vein, another important development to note is that Governor Hochul signed the Adult Survivors Act in May of 2022. Similar to the Child Victims Act, the Adult Survivors Act opened a one-year look-back window for victims who suffered sexual abuse in adulthood to bring a civil claim that was previously time-barred, regardless of when this claim occurred. The Adult Survivors Act allows individuals to sue entities and employers that may also be responsible for the alleged abuse. The look-back window for the Adult Survivors Act opened in November of 2022 and will close in November of this year. In anticipation of possible litigation stemming from this look-back window, businesses should ensure that proper record retention policies are in place to prevent loss of any relevant evidence. And if you have any questions regarding defense of these cases or these laws and their developments, please feel free to reach out to anyone in the litigation department at Bond.
Michaela, thanks very much for that update, and please keep us updated as those decisions are issued by the court. So I'm going to wrap up the program this afternoon and by talking about the end stages of the recruitment process. And Kathy, if you could flip the slide. So we spend a lot of time, and you spend a lot of effort in the recruitment process, making sure you have a solid job description, a well-written job posting now that with our eye toward the pay transparency laws, most of the time spent in screening applicants and interviews is a cost associated with the process. And of course, it has to be legally compliant in terms of the interviewing process. We've talked historically about the legal pitfalls and risks associated with background checks and the proper procedures. And ultimately, you reach a hiring decision. You find the candidate that you want to fill this position. And that's where I really wanted to pick up, right? So certainly there are many issues in the steps here, but once we get to that process, what are we concerned about? And in particular, I've seen an uptick in several areas of dispute coming out of the wrapping up of the hiring process. So Kathy, if we could go to the next slide. All right. The issue here is more best practice rather than a particular legal requirement. The best practice in closing the deal and bringing the candidate on board as your employee is to have a written offer letter. And while the attorney that you work with will make sure that offer letter has the necessary components, I like to emphasize that this is the new employee's introduction to your your place of employment, your company, your agency. And so you want it to be welcoming. You want it to reflect the culture that exists at your workplace. Significantly, we don't want to inadvertently create a contractual commitment. And we've seen circumstances and case law that has spelled this out for us. So if you specify a salary and you say the salary is $75,000 per year, the fact that you mention the time frame of a year is not going to create a contractual commitment to continue employment for a year. But if you specify in the offer letter that this is a employment for the term of a year or 5 years or some other specified term, then yeah, that can be a binding commitment and have significant legal consequences. So you want to make sure that that language is appropriate. And again, phrase properly if your intention is that this is an employment at will opportunity. You can say that, and you can affirmatively state that this is not a contract of employment and does not establish a term of employment for a particular period of time. But you want to put that in words that are consistent with the culture that you have at your workplace. You want to have a description of the duties and the time commitment. Is there is this an on-site position or a remote position? Of course, you're going to identify the salary, bonus opportunity, etc. And generally, you're going to make just reference to the benefit plans, the benefits that are available, except in those circumstances where you want to call out a particular benefit. Maybe you're a market leader with respect to your 401k contribution or the time off that you permit, and you want to highlight that as a way to entice the individual to accept the offer. But by and large, it's a reference back to existing plan documents and policies. Ordinarily, this is a conditional offer of employment. And certainly one of the conditions is that the individual can establish that they're authorized to work in the United States, right? You're going to have to go through the I-9 compliance process at some point, and you want to make sure that the offer is contingent on their being able to satisfy that. You may have other contingencies. You may hold the background check until this point, or a medical exam, or a drug test, all permissible to spell out in the offer letter. So then let's turn for a minute, and Kathy, if you could flip to the next slide. What are some of the issues, complications that we're seeing? The first one, and this is certainly ramped up in recent years, is the question of restrictive covenants, right? Is the individual you're hiring subject to some restriction based on his or her current employment? It might be a non-compete, it might be a non-solicit. You want to know that, and you want to have a procedure in your recruiting process to make sure that those get surfaced, right? So typically, what I see is a communication to the candidate, perhaps an additional condition on the offer letter that they identify any restrictive covenants that they are subject to, so we can evaluate whether or not it's an enforceable restriction, and if it is enforceable, whether the individual is still the right candidate for us, given the restriction that they may have. And ultimately, if you end up hiring a person who has a restrictive covenant, you're going to want to have a protocol in place to make sure that the services that they provide for you, the information that they bring to you, is consistent with that compliance with those obligations. You may have your own restrictive covenants, and some clients put those in the offer letter. They add the non-compete, non-solicit language, the confidentiality language right in the letter. More often than not, there's a reference back to a separate document that the employee will be required to sign as a condition of employment with you. I referenced just quickly, if you're talking about someone who is some of their compensation is based on commission, we've got to satisfy the requirements of New York Labor Law 191 and have a clear written statement that the employee executes, defining the terms under which commissions are earned and paid. The second area that I really wanted to focus on in terms of potential risks is with withdrawing the offer. Right. Again, we've seen this happen from time to time. And it might be that there is a new fact that comes to your attention about the individual, or it might be that there's a change in your business circumstance and the decision is made that we're not going to proceed with this hire, but we've already made the offer and the individual has accepted the offer. What are the risks? Well, if this is structured as an employment at will, we know that that means that it can be terminated at any time for any reason, as long as it's not an unlawful discriminatory reason. So it is permissible in that circumstance where an individual has been offered a position and that individual has accepted the offer but has not started yet, for the employer to make a decision to terminate and withdraw that offer. If it's structured as an employment at will, it's not a violation of the terms of the offer or the terms of the employment. There are some circumstances where that creates some risk, and it typically involves either a specific promise or some measure of fraud in the hiring process. The two examples, interestingly, that we cite in the text on New York employment law is a statement to the effect that the individual is hired and you can expect to be a vice president within a year. That forward-looking statement is not going to give rise to a claim of fraudulent inducement or promissory estoppel. On the other hand, if it's a promise of a much more specific promise, and the case cited in the text was a promise that the employer would double the salary of the employee, that might give rise to a claim if in fact that was a untruthful statement the time was made and intended to induce the employee to come on board. So some potential risks associated with withdrawing an offer. I think we recognize that most employment arrangements are employment at will, but there are circumstances where you want to have an employment agreement. You intend to induce the individual to come to work for you for a particular period of time. And oftentimes in those employment agreements, you take preemptive steps to control potential disputes, either through an arbitration agreement. And we heard from Travis some limitations on that technique. And I think we can anticipate continued limitations on the effectiveness of an arbitration agreement. An alternative approach is to have a jury waiver in the employment agreement, and that's a commitment from both parties that if there is ever a dispute, they agree to have the matter resolved by a judge. And even though it's the kind of case that could go to a jury, the parties agree in advance that they're waiving their right to pursue a jury trial. That can be very advantageous to employers. And in fact, recent studies suggest that employers face greater risks in jury trials than other defendants do. Just two final notes. Oftentimes in the hiring process, you are involved in salary negotiations, and we want to be mindful of the regulation both at the state and New York City level that prohibits the use or reliance on prior salary information. And ultimately, when we bring someone on board, we want to make sure that our process includes compliance with the Wage Theft Prevention Act, so that the individual is notified of their wage, and if they're non-exempt, their overtime, the arrangements for overtime pay. Okay. Those are the topics I wanted to cover. If I could paraphrase Humphrey Bogart, we go through the right steps and it's the beginning of a beautiful employment relationship. Thank you very much for joining us this week. Look forward to having you again next week. And for those in upstate New York, stay safe. The storm is pretty nasty. But thanks very much.